Thank you very much, Mr. Chairman, dear sirs, madams, ambassadors, and dear judges. I would like to present basically 5 observations concerning this litigation, having in mind that this case law, by its essence, is epistemological one. There are so many differences in legal cultures and histories of the countries, members of the Council of Europe, and I will try to, by showing you these 5 observations, that this case was viewed by Lithuanian Bishop Conference as third party in this litigation, in that perspective. My first observation would be, and I would like to start with the words of the President of the Lithuanian Bishops' Conference. He stated that the decision of the Strasbourg Court opens the way for businesses to profit at the expense of the dignity of other members of society. Such advertising has nothing to do with the critique of religious beliefs or ensuring a diversity of opinions or the competition of ideas in a free democratic society. The court in this case failed to notice the profanation of Jesus and Mary's images for commercial profit-making purposes. 2 questions would be added to this observation of the President of the Catholic Bishops of Lithuania. First, why in Lithuania there are so few advertisers who chooses to advertise by instrumentalization of religious characters, saints, or religious symbols? Second question, why even the advertising community in Lithuania, which is a self-regulating body, decided that this type of advertisement was violating public morals? And 2 observations could be made to this aspect. One is this type of advertising, this approach is an easy one. As was stated before by our colleague, this does not require too much of artistic work, because it's very easy to take religious character, to add commercial brand, and to get attention. If you take the Black's Law Dictionary to this matter, what is advertising? Advertising is an act of drawing society's attention with the aim to sell. Second, it is a pity that European Court of Human Rights limited its analysis on the basis of dichotomy between religious purposes and non-religious purposes. Commercial purposes was not introduced in the analysis. Second observation. Judge Gaetano, in his concurring opinion, stated that this judgment does not give carte blanche to the use of religious symbols, whatever the medium, context, or message intended to be conveyed. A state may legitimately consider it necessary to take measures aimed at repressing certain forms of conduct, including the impairing of information and ideas judged incompatible with respect for the freedom of thought, conscience, and religions of others. But the question is, what are the criteria? As was mentioned before, what are legally discernible criteria which would help for judges, national judges, governments, and authorities to have legal certainty in pursuing this aim as described by Judge Gaetano. Inequity in commercial interest with freedom of expression, the court's decision dangerously opens the way for people in seeking to achieve their commercial goals to profit by attacking the religious sentiments of the faithful in the society and profaning their religion. If you look to the decision Sekmadienis versus Lithuania, court makes some effort to enumerate each type of reaction. For example, that there were 4 calls to National Authority of Consumer Protection. But the court fails to capture the deeper aspect of that reaction. For example, Catholic Church in Lithuania was one of those powers which helped Lithuania to develop its culture, to live through a communist regime, and to regain its independence. That's why I mentioned, as I mentioned at the beginning, it is a epistemological question. Another observation. There is no criticism in those representations. The court, in paragraph 81 of the decision, states that in pluralistic democratic society, those who choose to exercise the freedom to manifest their religion cannot reasonably expect to be exempt from all criticism. Court states, they must tolerate and accept the denial by others of their religion beliefs, and even the propagation by others of the doctrines hostile to their faith. This observation is, from our point of view, quite a weak one, in the sense that, as I defined before, the act of advertising, it may have this aspect of provocation, yes, it may have this aspect of criticism, but in lato sensu, but court does not argument clearly and articulated in an articulated way to say in what way this advertising campaign was criticism. For example, court says, in the court's view, even though the advertisements had a commercial purpose and cannot be said to constitute criticism of religious ideas, the applicable principles are nonetheless similar. Having no other developments on that issue, there is quite a significant absence of articulated argumentation to see in what way those applicable principles should be applied in this case. Now I will go to concerns regarding emotional interjection, which was defended by the parties. Court in paragraph 14 said that the applicant company submitted written explanations, and they firstly submitted that in advertisements the word Jesus was used not as an address to religious personality, but as an emotional interjection. If you analyze the the argumentation of the court, you would see that court would support that idea. But this idea does not stand one argument. For example, as I stated before, in Lithuania, not only religious symbols are protected in advertising, but because of the history of Lithuania banned usage, production, and distribution of Nazi and communist symbols. That is to say, because of our history, Lithuanian history, as I mentioned before, because of communist Russia occupation, annexation of Lithuania, Lithuania chose to say to its society that at this point we choose not to use those symbols. We choose not to distribute those symbols. So, there will be one last procedural aspect of this case. When this case reached European Court of Human Rights, the Ministry of Justice asked 3 questions to the Bishops' Conference. First one was, what is the part of the society which identifies themselves as religious? And at that point, 77.2% of the population of Lithuania were Catholic. Second question was, what is the significance of the Catholic Church to Lithuania? And that significance is very, very of much importance, big importance. And third question was, what are principles or canons, how the representation of Jesus and Mary should be reproduced and done? In this case, at that stage, the Lithuanian Bishop Conference was like an expert rather than a party. And to conclude, I'd like to go to first to sum up the aspects observations that I made. First of all, that is a wide opening based on tiny ground, which can have vast consequences. And for Lithuanian case, it is the case. This case law is a carte blanche, but when there are no criteria based on which we can decide whether it's carte blanche or maybe carte bleue, this case law contributes to legal uncertainty. Third aspect, the distinction which was not introduced or even abandoned by the development and reasoning of the court is the commercial interests versus instrumentalization of religious symbols. And fourth, Lithuanian Bishop Conference in that decision and in that case cannot see criticism in those representations. So, we hope that it is an isolated case, but if it's not, this will contribute to the reduction of the authority of the court. Thank you.
Merci beaucoup pour votre présentation.